restaurant owner. We have the people who put Schumacher Motors out of business. They shouted obscenities, they shouted threats, they vandalized the business, they issued death threats to people buying the furs and to the customers. But Judge Boston looked at the evidence of the specific defendants. Did this specific defendant throw blood on the store? Did the specific defendant, make a threat to kill someone? And it hadn't happened, and all those defendants were dismissed. And then we have the Supreme Court case of NAACP versus Claiborne Harbor Company. And again, the Mississippi courts were, this was a design, some defendants were acting for the others, they engaged in acts of physical force and violence against the customers, and so bang, they're all guilty. And the Supreme Court made it clear that it doesn't matter if shots were fired, or bricks were thrown, or tires are slashed, or people are beaten up, if you don't have those defendants in front of you, because of the First Amendment, because we can't chill off all political expression just because there may be some people who overreact and do something that we can then attack, that we can attack the people who didn't do anything. And Patriot Card's not a membership group. That's not disputed. And even if it were, you read in NAACP, you can't attach liability by virtue of association, because that would interfere with First Amendment associational rights. You have to prove that the group's very goal was unlawful, and there was a specific intent of the person to achieve this unlawful goal. And so that comes back to, is it unlawful to protest a fur business or to protest a cider ripe business? And it's not, because it's political and it's allowed. Now, I think the plaintiffs haven't really articulated their basis for holding Mr. Gibson liable very well. In the negligence context, they cite that uniform jury instruction, 20.07. But that jury instruction requires a finding that Mr. Gibson was himself negligent and caused injury in a way consistent with the First Amendment law. So that doesn't really answer the question. So then they use words like, well, he coordinated, or he led, or he instigated, or he goaded, or things like that. But there is no case law of people who have been held liable in a demonstration for goading or instigating. They have to issue a specific, something that crosses the line. That's what's never been articulated here, is what crosses the line. In NAACP, it says, we want a showing that there is an authorization, direction, or ratification of specific tortious activity. And we're going to see some video that when people are throwing things, don't throw things, he says. Calm down, don't throw. He is not telling people to go and step over the line, not himself personally. And that's essentially the core of the motion. And I want to get to the evidence, the video evidence, because that's sort of the time-consuming part of the presentation. But before I get there, I want to talk a little bit about the standard of review. Now, this is tough. But let me start with the legislature's policy. Strong policy to get these cases resolved quickly, cheaply. If we'd gotten this done in 30 days, I wouldn't have a problem with all these filings, right? And
that does remind me, I should say for the record that I'm supposed to find good cause for not hearing it within 30 days. Find good cause for not hearing it within 30 days because of the court stocking constraints. So thank you for that reminder, Glenn.
And the purpose is so strong that when the courts began to whittle away at this remedy last time, in 2009, the legislature stepped in and said, look, we want to provide the defendant with the right not to proceed to trial where the plaintiff's not meeting the burden, and this section is to be liberally construed in favor of the rights, exercise of rights of expression. And so then we come to what is the burden? And the statute is sort of confusing. The burden is to establish that there is a probability that the plaintiff will prevail on the claim by presenting substantial evidence to support a prima facie case. And what does that mean? The most authoritative statement of what it means is sort of this footnote discussion in the Handy case. And they distinguish between a prima facie case being sufficient to get to the jury or evidence sufficient to shift the burden of proof. And they say it's more the former than the latter. And so what we need is we need some sort of substantial evidence, substantial enough to say, yeah, the jury should consider this. And I think the only way to implement the standard in a way that provides the relief that the legislature wanted to provide is to have them present evidence that there's really a genuine issue of material fact that requires the jury resolution, that sort of would infringe their constitutional right to trial by jury if they didn't get it. And we think, if you look at the evidence, you can find no juror who is following the First Amendment rules could find that Mr. Gibson stepped over the First Amendment line. And this is not just an issue under ORS 31150. You know, there's the ORS 31150 universe, but there's also the long line of Supreme Court cases that impose upon courts a special duty to protect defendants from local prejudice. And there's the Snyder case with the horrible people protesting at military funerals, and the Supreme Court says, look, the jury's unlikely to be neutral in this case. And so it's not just about, voir dire or something like that. In a context where the community regards my client as some kind of violent Nazi or something, it comes to the court's job to uphold the First Amendment and make this determination of law as to what the line is. It's not really a jury question under the Supreme Court cases. Now, one of the things that makes it complicated is that plaintiffs submit these videos to the court, and then they submit testimony about what's in the videos, and then they submit testimony. And so we have a lot of things going on here. I want to suggest that two important legal principles. First of all, a lot of opinions about what is shown, they're only admissible if they're rationally based on the perception of the witness and if they're helpful to a clear understanding or determination of the fact. And I want to suggest that when people say things like, well, Mr. Gibson attacked the bar, that's not very helpful. The question is what he did. And what he did is in the videos. And it can be called an attack or not. But you can't draw the First Amendment line just by saying, well, he attacked the bar. That has images of pure nation with their hatchets or something. And that's not what happened here. And the other thing is, we have a line of cases in the Supreme Court, for example, that says, and I understand this has been developed in the summary judgment context, but why shouldn't it be the same here? That when you have a witness who says something that's completely contradicted by the video, and I'll show you some of that, it's the video that's controlling, and it's not the affidavits that are controlling. Because if you don't follow that Supreme Court line of cases in giving the video primacy, you allow plaintiffs to undermine the anti-slap remedy by just putting in affidavits that say, say things like, Mr. Gibson's mom showed up and locked the door and no one could get in and out, and blah, 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 blah. And it's completely untrue. And it would undermine the remedy if they're allowed to go put in the video and then put in something false about the video and ask your honor to defer to what is false. So
let me kind of ask you a question about that point. I understand what you're saying with regard to the court's ability to look at two competing pieces of information and then disregard something that is, obviously false based on the disparity between the two pieces of evidence. But you also mentioned in your reply that there's some tension between Handy versus Lane County, which is a Supreme Court case, and then Young versus Davis, which is a Court of Appeals case. And I'm not sure that I saw that tension. And I'm wondering if you can flesh that out a little bit more. There may have been some tension as far as how the Court of Appeals characterized the plaintiff's burden of proof under the second prong as being minimal merit. But beyond that, I don't know that there's much tension that I saw, but I wanted to know if you saw something that I missed.
Well, I think I was focusing mostly on the minimum merit.
Sure.
But I would also say that Young was before Handy. And after Handy, we have the Wingard case. And I think the Wingard case goes into this burden of production. And burden of production isn't really explained very much. And that's why I cited the Durham versus City of Portland case, because the idea of burden of production is an idea that, again, brings the court in for some kind of role that's greater than just, well, someone said something, and so we have to go to trial. And so I don't think, frankly, the law is very well developed in this area, because there are a lot of cases in the wake of Handy besides Wingard that explain this. But I think it's clear that when it talks about the burden of production, we have to give some feel to the legislative language in terms of, you know, what has to come forward is something that's enough to create a jury issue.
Okay, so setting aside for a moment your example of a video being completely contradictory to statements made in a declaration, and therefore crediting the video and disregarding the declaration if that contradiction is obvious. Let's instead say that we have a declaration filed by plaintiff and a declaration filed by defendants, and those are contradictory, and it's sort of reasonable minds to differ sort of situation. Are plaintiffs correct that in that situation I am not to weigh the evidence under the standard of review, and that I am instead to simply sort of consider whether or not a rational trier of fact could conclude that plaintiff's version of events is the correct one?
Yes, I guess what I would say is that the question of whether a rational trier of fact could conclude something is a question that cannot be answered without something called weighing. I think what Young was all about was the Young trial court weighed the evidence. He said, here it all is, I'll read it all, and by God, it's not more likely than not that the plaintiff will prevail. And he was essentially stepping in to be the judge. We know that's too far.
Okay, so that point of law from Young is still a good law here.
That's the whole. That's the whole.
And that holding has not been superseded.
Right. Yeah, you are not allowed to say, I've looked at all the evidence and I don't think PATRIOT is likely to prevail, so Mr. Gibson wins. Okay. I understand that. The question is, what does the burden of production mean in a context where the legislature has asked the court to consider both affidavits, command from the legislature, and see if it establishes substantial evidence in a prima facie case. And so that's when we get into what is the burden of production in a First Amendment case? What is the role of the court in a First Amendment case? And that's why we urge the court to follow the Supreme Court authority that says, you know, the court's got to draw the line here.
Okay, and so that answers my questions about the standard review on the second prong. I also have a question about the standard review on the first prong. Okay. Plaintiffs argue essentially that I should look only at the allegations in the complaint and sort of treat it like a Rule 21 motion, in that I should assume the truth of all well-pled allegations in determining whether or not their claims arise from this protected speech. But it sounds to me like in your argument, your position is that I should look beyond the four corners of the complaint to the evidence that's been presented to determine whether or not plaintiff's claims arise from the protected speech activity.
Yeah, I think you have to. Otherwise, there would be no free. I mean, think about if it were a defamation case. Plaintiff defamed me. So is that right there in the complaint? Well, defamation is not protected speech, so the plaintiff wins. The antislap procedure doesn't work then. So, you know, Joey Gibson attacked this or whatever. Well, what kind of attack? You know, what exactly did he do? They didn't allege that Mr. Gibson threw rocks. They didn't allege that he pepper sprayed anybody. These words that they use are words that have to be fleshed out with the affidavits to understand what they mean.
And that might be a fine distinction between what I'm talking about and the example that you just gave, is that let's assume for the moment that their complaint is more than conclusory language like so-and-so defamed so-and-so, and that there are facts, ultimate facts pled sufficient to state a claim that is not protected by the anti-slap statute. Do I still look beyond the complaint in that situation to the evidence presented?
Yeah, I think you have to, because the legislature has commanded the court to review the evidence filed by the defendant.
And do I do that? Then are they talking about just the second prong when they say that, or are they talking about the first prong too?
I think they're talking about the first prong, because I think that the anti-slap motion would be useless if the answer is that we only look at allegations. The whole purpose of it, here's the complaint, and then the defendant comes in with affidavits. And why? It doesn't work otherwise. It would eviscerate the anti-slap motion, and it would never apply. I can't think of a case where it would apply if the plaintiff artfully pleads some kind of thing that isn't the First Amendment. And we haven't briefed that question, and maybe we should, because there's been a lot of law on the question of, on that question. But we maybe should bring the court's attention. But I don't think there's any case that says that you are entitled to essentially take the allegation of crime as true. So that's the end of it right there. That's not in any case that I know. And even the one they cited. That being said, I'd like to play some video, probably too much video. I'll urge the court to interrupt if it wants something played again.